Welcome back to the Making International in Korea video series. In this video, I will explaining to another primary source of international law, which is the customary international law, along with general principles of the law recognized by the civilized nations. Customary international law is a source of international law, though not as obvious as treaties. However, it is nevertheless a very important source of international law. I will begin by explaining to you about what is this customary international law, and then discuss what general principles of law are and what role it serves as source of international law. Article 38 of the Statute of the International Court of Justice established that the international custom as evidence of general practice accepted as law as part of a corpus of international law. To prove the existence of customary international law, it is necessary to find the elements of the first, consistence, the state practice, and second, opinio juris, or a sense of legal obligation. The state practice is the first element of the customary international law. For example, according to the very important case of the International Court of Justice, which is the North Sea Continental Shelf case, to prove the first element, the state practice should be both extensive and virtually uniform. Evidence of state practice include the administrative act, legislation, decisions of the courts, and activities on the international stage. Treaty making, along with activities undertaken by the state legal officers, legislative institutions, courts, diplomatic agents, and political leaders. Also, relevant evidence for state practice includes resolutions in the UN General Assembly. The comments made by the governments on draft produced by the International Law Commission, decisions of the international judicial institutions, decisions of the national courts, treaties, and general practice of the international organization. In determining uniformity of state practice under traditional rules of international law, the customary rules reflected the express or the tacit consents of all states, and as such, for customary rule to emerge, there has to be compliance from all states, at least implicitly, for the custom to be recognized by a hard rule. However, under the modern approach to the question, the possible instances of the non-compliance does not necessarily mean that the rule has come into being, which is reflected into a very important case of the ICJ, a Nicaragua case. Some argue that the customary rules does not need to be supported or consented to by all states. For rule to take root in international dealings, it is sufficient for majority states to engage in a consensus practice corresponding with the rule and to be aware of its imperative need. So that the consensus practice is very much important when you define the customary international law. Opinio juris is the second element of the customary international law. Opinio juris is described as the psychological element of customary international law. It raises the questions as to why two states engage in a particular practice. It is for economic, the political or military demands, or the self-interest? Or if it is, then this is not state practice for the purpose of customary international law. A state may eventually come around and feel at some point they engage in the practice because they feel legally obligated to do so. At this point, it gradually crystallized into customary international law. Examples of the customary rules that began as practice based on self-interest and then later turned into opinion juries, include the rules on the continental shelf and on the outer space, for example. Relations between customary international law and treaties are, in this regard, very important to define. The relations between customary law and treaty law were governed by the three general principles, which in all legal orders regulate the relations between norms deriving from the same source. The first, a latter law repeals the earlier one, and second, a latter law, general in character, does not derogate from an earlier one, which is special in character, and third, the special law prevails over a general law. The complete interchangeability of the two sources plainly sanction the wishes of sovereign state not to tie their hands for good, which means that they are able to dispose of their obligations by mutual agreements as soon as fulfilling them proves contrary to the parties' interest. In this regard, it is very interesting to note that there should be persistent objective rules. For example, the United States has asserted that the states are not bound to new customary international rule if it has consistently opposed the practice before it crystallized into a hard rule. The underlying rationale is that, given the consent-based nature of international law, a state should not be liable for rules it has not given its consent to bound to. The rejoinder to the United States position is that there is no support in state practice and international case law for the persistent objective position, and the presence of the robust international community has placed the fundamental values of the global community over the prerogatives of individual states, including great powers. Let me move to the general principles of the law. A fundamental issue arises as to justification for the application of the general principles of law, as these principles do not seemingly arise from explicit state action like treaties or customary international law. The issue presented is whether there are sources of international law that do not exclusively emanate from state consent. This question highlights the tensions between the consent and non-consensual based theory of the international law. The consent and non-consent is very much important when you define the obligation and rights of the international law to each state. Underlying consent based on the justifications is the notion that international law emanates from state action, evidencing consent to international rules. Consent-based justifications rationalize the uses of the general principles of law, in part through the agreement of states to create international court of justice and authorizing courts to apply the general principles of the law. In other adjudicative context, the uses of general principles is justified through consensual agreement among sovereign states to utilize general principles of law. State has these general principles in their own national legal system, so they do not object to use these same principles in their relations with other states. However, in contrast, non-consent notion of international law rests their position on source of law that exists beyond the state, as illustrated by the Daskam's proposal in a creation of the Permanent Court of International Justice, and that the courts apply the rules of international law as recognized by legal consents of civilized nations. He sought to expand the source of international law by making applicable the fundamental law of justice and injustice, deeply engraved in the heart of every human being, and which is given its highest and most authoritative expression in the legal consents of civilized nations. The term legal consent is another way of describing what is gained from the natural law. For example, Francisco de Victoria and Hugo Grotius, two of the earliest European commentators on international law, believed that the source of international law could be found in natural law and law of the nations. For example, Grotius understood natural law to be the dictate of the right person and right religion, indicating that an act from its agreement or disagreement with the rational and social nature of man has in it a moral turpitude and moral necessity, and consequently that such an act is either forbidden or commanded by God, the author of nature, while law of nation refers to the category of public law that encompasses rules that govern the relations between different nations. Article 38.3 of the Statute of the International Court of Justice again was the result of the compromise between these two justifications of the general principles of law. It is commonly understood today that the general principles of law are viewed gap filters to be utilized in the absence of treaties or custom. The consensus approach to understanding the general principles of law is that the certain legal principles are so fundamental that they will be found in virtually every legal system. It has been referred to as indirect evidence admitted in all systems of law that is recognized by the international decisions. More specifically, according to Oppenheim, the very famous international lawyer in his generation, the intention is to authorize the ICJ to apply the general principle of the municipal jurisprudence, in particular private law, insofar as they are applicable to the relations of states.